Okay. Good morning, everyone. Welcome to the Board of Behavioral Sciences Policy and Advocacy Committee meeting. Today is, February 7th, 2020, and the time now is 10:36 a.m., and we're in Sacramento, the Department of Consumer Affairs office. So I think the time now is for Christina to call a quorum
Yes, good morning. Christina Wong,
here.
Deborah Brown, Betty Conley.
Here.
We have a quorum.
Thank you very much. So this time now, let's have everyone introduce themselves. And so I will start with the board staff, board members, and then for the public, your introduction is voluntary, but strongly, highly recommended. So let's start with, on my right, Steve.
Hi, I'm Steve Sodergren, the Assistant Executive Officer of the Board.
Christy Berger, Regulatory Analyst for the Board.
Roseanne Helms, Legislative Manager for the Board.
Betty Conley, LEP Member.
Deborah Brown, Public
Deborah Brown, Public Member.
Sabina Knight, Legal Counsel.
Christina Wong, LCSW member.
Kim Madsen, Executive Officer.
Good morning, Kenneth Edwards, Executive Director, California Association for Licensed Professional Clinical Counselors.
Good morning. I'm Jennifer Alley with the California Marriage and Family Therapist Association.
Janley Wong, National Association of Social Workers, Gong Hei Fa Choi.
I agree.
Good morning, Ben Caldwell, licensed MFT.
Hello, Jerry Shapiro, School of Social Work, San Francisco State.
Welcome all, and Gong Hei Fa Choi also, Chinese New Year, right? I think our next agenda item is the approval of the August 2nd, 2019 committee meetings minutes. So I'm going to open for discussion. Any changes? Any amendments? No? Any public comments for the minutes of August 2nd, 2019 committee meeting minutes? Okay, so I guess that we can, I need a motion.
I move to approve the minutes.
Okay. Second. So, any other discussion? Thank you. Nope, okay, we're ready for vote.
Okay, Christina Wong,
Yes.
Deborah Brown,
Yes.
Betty Conley.
Yes.
Motion carries.
Thank you very much. So we have another approval, and that's the meeting minutes for the October 11th, 2019 committee meeting. So any board members, comments, changes, amendments? No? Public? Okay, so motion, I'll move to approve the October 11th, 2019 committee meeting minutes.
Second.
And Betty second. Any other comments? Okay, we're ready.
Christina Wong,
Yes.
Deborah Brown,
Yes.
Betty Conley.
Yes.
Motion carries.
Thank you very much. So our next agenda item is, let's see, it's about the notice to clients about filing a complaint, and I believe it's Roseanne.
Yes, so
you.
this is a continuation of an item we discussed at the last November board meeting. The board sponsored AB 630 last year, and it amended the law effective July 1, 2020 to require that an unlicensed or unregistered individuals providing psychotherapy services in exempt settings provide their clients with a notice of where to file a complaint about the therapists. It also extends a similar requirement for board licensees and registrants, just saying that a complaint can be filed with the board. There's a couple of clarifying amendments that we thought that the board might wish to consider for the provisions of AB 630. The first amendment is an amendment that the Senate Business and Professions Committee suggested last summer. They didn't require it to go into AB 630 at the time because it would have held up the bill, but they asked that we discuss it further later. The language would add some information that's shown in italics on the first page of your memo here that basically says the board receives in response to complaints regarding licensed therapists, and if you're unsure if your therapist is licensed or registered, that you can contact the board. So we thought that might be helpful to amend into the language. So that's the first item for consideration. And at the last meeting, we tweaked the language a little. We added the word practitioner in lieu of the word counselor. So that change is reflected in your packet here today. However, during the discussion at the last board meeting regarding this particular change, another possible unintended consequence was brought up by stakeholders that we thought warranted further discussion. And so what that particular item is it's about the timing of providing notice to the clients of this notice. The law says that the practitioner must provide the notice to clients prior to initiating psychotherapy services. And an interesting point was brought up about when beginning session-based therapy, most of the time under traditional circumstances, that requirement would not be difficult to fulfill. You start therapy with a client before you start your session, you provide the notice, and that way they have it going forward. But there was a concern raised that if it was a crisis situation, then what do you do in that situation? It might not be feasible or appropriate to stop therapeutic services immediately to discuss and deliver the required notice. So staff looked into this a little bit further and suggests some language that's been amended into the proposal, basically stating that the notice must be required either prior to initiating psychotherapy services or as soon as practically possible thereafter. By doing that, it provides clarity that in a crisis situation, if it's not feasible to stop right away to provide the notice, they can do it as soon as the crisis has been addressed, as soon as it's practical afterwards. This language was developed, I looked at the mandated reporting, child abuse law, and also elder independent adult reporting law, and it had some similar language in there, and so I thought that it might be appropriate. The committee might also wish to discuss in the proposed language on page 21, I also included a sentence after the content of the notice that says the delivery of the notice to the client shall be documented. I noticed that that was also in telehealth law, that you're supposed to document consent for telehealth, so I thought that might be a good idea. So we could discuss that. If you have any concerns about it, we can take it out or we can decide to leave it in. That's up for discussion. So I'll open it up at this point.
Thank you very much, Roseanne. So board members, any feedback about the language suggested by the BNP committee? Is a committee? Mm-hmm. Yes. And adding the practitioner and also addressing about the timing of the providing services. Betty?
So when I read this, I'm 100% in support conceptually. I don't like the word practicably. As soon as practicably, practicably. I mean, I don't even know that that's, I mean, I'm sure it's a word. It didn't show up on a spell check error, but it's, I don't know whether there'd be a better word. Is reasonably helpful to, reasonably possible or logistically I don't know. Something, I just don't like that word, but I'm not going to hold it up if nobody else has a problem with it.
So Roseanne, according to your explanation, so that language is consistent with the child abuse law.
Yeah, it's in the penal code. And
so that's why they use that.
And I even looked up because I thought it was a weird word.
Weird word,
It is, and I looked it up and it is a word.
Okay. So if it's consistent
but it
with
is
some other practice.
Yeah,
language.
it is. It's in the penal code. It says it says immediately or as soon as practicably possible, and it's used throughout.
Then I withdraw my objection.
It is kind of an awkward. It's not a word that you hear a lot in the English language every day, but it does get its point across. So it's, I mean, definitely open to another word if somebody has a suggestion.
Yes, absolutely. So reason is right. It's like a thought. Practically means that, you do it in action. So that kind of, whatever, linguistically, you want to argue with it. But, but really, I think it's about, the essence is that, we want to take away that prior, and in the substitute of, that having a more flexible time. So the practitioner or therapist or whoever, that they're not getting into trouble because of they're not doing it before they start therapy. And I think I really like that concept also, and I don't have any problem about adding, that statement about as soon as practically possible thereafter. And also, I like the fact that, the documentation would be really good, so that they know, where to file the complaint, and they were informed. So I think that's really cool, and so I am very happy, with the suggested language. Any other? Deborah, any comments? No? Okay. And I'm going to open for the public. And Dr. Shapiro is ready.
Thank you. I think this really addresses a concern I had, but I think it communicates a kind of responsive conversation, and I really appreciate and respect it. I shared your concern about practically. Practically is kind of a penal code term of art. And I was thinking about how perhaps to recognize that, but also bring in the Board of Behavioral Science vision as it's expanding. And I commend the board for expanding your vision to recognize trauma-informed care and other circumstances that are emerging. So perhaps the possibility of practically or situationally appropriate or responsive, and that way we're covering the penal code standard, but we're also bringing the board vision into the conversation, not only here, but in future conversations. But again, I just want to say thank you.
Thank you very much. Any other comments? Hi, Jennifer, and welcome.
Thank you. So, this is a really good step forward, right, in making sure that my members' clients are informed and all that, and we totally support that. But on the actual notice to the clients, the first two paragraphs are somewhat a little bit repetitive, and maybe there'd be a way to kind of smooth it out or kind of condense the language, because it says the name or office or unit of the name agency receives and responds to complaints regarding the practice, unlicensed and licensed. And then down here it says the Board of Behavioral Sciences receives and responds to complaints regarding, you know what I mean? So it's very duplicative. And so I wasn't sure if they would actually have both of those paragraphs on the notice, or if the underlined one was actually the one that was going to be used.
Right. Well, I believe, Roseanne, correct me if I'm wrong, but the first paragraph addresses the actual agency.
Yes.
Where they're receiving services, and the second one addresses the board,
Okay.
the regulatory agency.
Yes, it's basically saying if you're not sure, then the board regulates it, and so contact the board. We could possibly in the second paragraph. I do understand what you're saying, and that is a good point. We could probably do without the first sentence of the second paragraph where it says the Board of Behavioral Sciences receives and responds to complaints, and we could just say if you have a complaint and are unsure, then contact the Board of Behavioral Sciences. That might solve it. It's a little bit of the second sentence is a little bit of a setup for them so they know here's what the Board of Behavioral Sciences is.
Right.
But we do say that, we do reference the board in the second paragraph, so we can discuss that possibility.
Thank you very much.
So thanks for bringing that, the sense that, from the public point of view, it might be repetitive. But at the same time, I'm also thinking that it might also add, some more clarity, because we reiterate that, this is the board's duty, to receive complaints. And so one sentence, Betty?
I would, gosh darn it, I thought I had that. I would say that it actually lines up consistently with the first paragraph, because the first paragraph says the agency responds for unlicensed people. The second paragraph starts with the board responds for licensed people. So, I think the second sentence actually does support the clarity of our mission. So that's my 2 cents.
Okay. Thank you. And
Kenneth,
can,
sorry.
No, you go
Kenneth from CalPIC. Just a clarifying question, and forgive me if it's been answered already, but counselors will provide this by way of the informed consent, or does it need to be a separate piece of paper? Can it be, so for example, in my private practice, the informed consent is electronic. So this would just need to be a paragraph within that or a separate thing?
Yeah,
Just so I'm as clear as possible with it.
yeah, the intent was always not to make it onerous on practitioners, and since you're already providing an informed consent, the vision was just adding this information in there.
Okay.
Yeah, it doesn't need to be separate. It doesn't need to be a separate document, but if you want to make it a separate document, that would be your choice.
Okay. All right. Thank you.
yeah, in our agency, a lot of those, those requirements are checkboxes. So if you add maybe like even one sentence and check, have you explained to the client about complaint? Yes, no. So I think that's, something, I think the implementation, I don't think for the language now confine the practitioners to do anything in any forms of ways to, to deliver, to implement that requirement. Yeah. So any other comments? Good, very good. So where are we at now? So it looks like, we like those changes. And it doesn't seem like that, the language itself is clear, it's acceptable, right? So no changes, all accepted, so I need a motion.
I move to accept the proposed language and recommend the board to go to the full board for consideration.
Okay.
I'll second that.
Thank you very much. Any other discussion? Okay, we're ready for vote.
Christina Wong,
Yes.
Deborah Brown,
Yes.
Betty Conley,
Yes.
motion carries.
Thank you very much. So let's move to the next agenda item is the discussion in regarding setting definition, bill proposal, and the supervisor work setting requirements. And Roseanne again.
Yes, so we have a bill proposal outstanding, and the language of the bill proposal has already been approved by the board, but there's one really technical nuance that in that bill proposal, so I wanted to bring it back for discussion, just to point out, to make sure that we're 100% clear on what it does, so that there's no intended consequences. There's kind of just one thing I want to tease out and discuss a little bit more. So we have the proposal, it's we're seeking an author right now, and it'll be introduced shortly, and it provides concise definitions of the types of settings where licensees and pre-licensees can work. The goal of the proposal is to reduce the confusion that we've had lately about where pre-licensees may or may not work based on how a business is structured. We get a lot of questions internally about businesses that don't look like a private practice, but they don't look like in an exempt setting, and what is that? And it almost sometimes feels like you need a degree in business, corporate law or business to answer the question. So we want to try to eliminate some of the confusion. So the language for the bill can be found in the attachments. Basically, the proposal clarifies all settings into two main types of settings: exempt settings and non-exempt settings. And then from there, we start breaking out different, more specialty types of settings that have a little bit more limitations. There's private practices, there's professional corporations that the board has decided those settings need a little bit more oversight because of the way that they're structured. So currently, the bill proposal limits supervisors in any non-exempt settings. We're proposing to limit the supervisors to 6 individuals or triadic supervisees at a time. So any non-exempt setting, any setting that's any one of those, 6 per supervisor. In current law, there's a limit of 3 per supervisor, but it's only on private practices and professional corporations. So we're extending that a little bit. So there's going to be, some additional businesses that don't currently have that limit, that are not private practices or exempt settings, are going to feel that a little bit right there already. So we are doing that. That's a new limitation. And then the proposal also requires currently that in a private practice or a professional corporation, the supervisor and associate can either be employed or contracted by the associate's employer, or must be an owner of can be an owner of the practice, and that they must also provide psychotherapeutic services to clients at the same site. That's a little bit of a departure from current law. In current law, we require associates in a private practice to be supervised by a supervisor who's employed there and practices there or is an owner. And we also, if the site is incorporated as a private practice, the supervisor must be employed at the site full-time and be actively engaged in providing professional services there. So basically, in private practices or professional corporations, we're allowing somebody to be a contractor now, but everybody has to, in those private practices or professional corporations who's supervising, must also be practicing at that site. So I just wanted to point out in that discussion, because the conversation came up, is whether it would be appropriate to extend this requirements to supervisors of associates and trainees in all non-exempt settings. Because private practices and professional corporations are carve-outs of non-exempt settings. There's other types of non-exempt settings out there that this is not going to apply to. And I think maybe that's okay, but I just wanted to have the discussion. Currently, the law does not place any such restrictions on a setting that does not qualify as a private practice or a professional corporation. We're already going to be restricting them now to 6 supervisees per supervisor. Which is why I would exercise a little bit of caution in extending this a little bit farther. It's possible that these sites, non-exempt settings that are not private practices or professional corporations, may have additional internal or government oversight that makes such a requirement less necessary. Some businesses that employ pre-licensed therapists have a number of different sites or branches, and many of them might have an individual employed just to supervise that kind of works tightly at 2 or 3 branches and travels around. We've heard of that sort of happening with just general corporations. And so therefore, we should weigh the effects of requiring practice at the same site for these settings against the often limited supply of supervisors. And then the effective trainees should also be considered. Trainees aren't allowed to work at private practices and professional corporations. So I just wanted to point out that little nuance so it doesn't become an unintended consequence later when we're implementing the bill. Due to the uncertainty of extending this limitation to all non-exempt settings, I would be more on the side of suggesting that we leave the proposal as written for now. The restriction on requiring the supervisors to practice at the same site would only apply to private practices and professional corporations. And then if concerns arose in the future, the topic could be reconsidered. But I wanted to bring it for discussion.
So just to bring everybody to be on the same page. So maybe, to help, the board and the public to clarify, now what is that examples, of the non-exempt setting and yet fall out of those 2 groups that were the carved out professional corporation and private practice.
There could be just general corporations, like we hear a lot from Kaiser,
Hospital.
or like a dialysis company, or just a general company that provides therapy at its site that's not incorporated as a professional corporation. If you look them up, they might have a government contract and they're providing therapy, but they're not an exempt set. They're not a government agency. So we see those kinds of settings, and sometimes they will have maybe 2 buildings and a supervisor floating around, and so we see that kind of situation a lot.
Okay. Yeah. Okay. Good. Betty, you have some thoughts. Yeah.
I'm completely in agreement with Roseanne. I think this is one of those that could result in significant unintended consequences, and I suspect that we would hear about that from all of those entities that would be impacted. So I would want to be very cautious, and if we at any point considered moving forward with this, I'd want to get some definite feedback from some of those entities and really look at the consequences before we made any changes. I 100% agree with Roseanne.
I think the same way too, because I think, the whole set of the supervision law, it's pretty new. So, we don't know really the magnitude of how things, have changed. I think I recall, there are already practitioner come and say, that how that is going to impact their private practice. So I think, we probably using that wait and see approach is not a bad thing, just to see how things roll out and, if staff can continue monitor this area, I think that would be really good, because it is, I mean, I get, the unintended consequence. But at the same time, when I'm trying to think about, the amount of the entities, and how much, trainees, associates and licensees work in those settings. And I think, that is also another area that we certainly, need to continue to monitor because right now it's kind of like, falling out of our scope.
Right.
So, so that's my suggestion. And Deborah, you have any suggestion?
Comment. Do we have in place an opportunity to do periodic audits on corporations, companies, private practices who take in associates, send them out to non-exempt settings, and then the therapist is doing their hours and making sure they have their hours, but the person who they, under the guise of that particular therapist, has an expired license. They're not supposed to be even practicing, let alone supervising associates that are out at non-exempt. And then when they find out, the poor associates have to get forfeit all the hours that they were working because they assumed that the person they were working under was legitimate. And I was just wondering if there's any kind of audit that we do that when we're sending out, when these private organizations are sending out associates or even people that they've employed out to non-exempt areas, that they are themselves legitimate in supervising them.
The board does not do a proactive audit. We catch it on the back end, and that's one of the changes that we're proposing with the self-assessment of the supervisors in charge, is that that's going to be one of the check boxes at the beginning of their supervisor relationship. It'll be the, license, you've completed the supervising training, you get that type of thing to at least give that associate a heads up that, oh, my supervisor, their license might expire in 6 months or in a year, to advise them to just sort of monitor that. So,
Okay.
yeah, that's the best we can do, because otherwise that would be almost like a pre-employment checklist. And we would not, A, that's not in our arena, and B, we don't even have the bandwidth for it.
Okay.
So,
I have just a observation, and this is very exciting too. So we work very hard on the exam setting. And, and then so we have a committee, and then we have another committee, to work on the supervision. And this is actually kind of like the marriage now, the implementation, for these two sets of law. And so, it's actually, really fun that we're now starting to find, these possible, areas that we touched or not touched. And so I think that monitoring is great, whether it's, monitoring the supervisor, but at the same time, I think, for me, the exciting thing is that we're going to really tighten up, the supervision and the exam setting. So we'll see how things go, because I think that is a very legitimate concern. So I'm sure that that the board staff would continue to to kind of keep their pulse on it. Yeah, thanks, Deborah. And Ben, thanks for waiting.
Good morning, Ben Caldwell, MFT. Roseanne, thank you for bringing this forward. A couple of potential unintended consequences here, and I apologize for raising these without having a proposed solution, but just something to keep in mind. One would be for those supervisees who are doing home visits. That sort of begs the question of, does the supervisor have to be doing visits in those same homes because that's a location of practice? And the other question, probably a little more technical, I'm not aware of any problems that have come up as a result of this, but it at least raises questions about telehealth. Because when we're considering for sort of enforcement purposes where therapy takes place. If I'm working with somebody who's outside of California at the time of service, that therapy is considered to have taken place where the client is. So just two factors to sort of consider here that I think supervisors would have questions about. And these apply in the other non-exempt settings that you're talking about, but they also are questions in the private practice context. If I'm in a private practice and I have supervisees, can I have those supervisees doing home visits with clients without violating that section of law? To my knowledge, that's kind of an open question.
So I think the way that I would respond to that is looking on, we changed some language a little bit with AB 93 and looking on page 44. If you see section 4980.43.4A, we changed that particular sentence last time to say that the trainee or applicant for licensure or associate should only perform mental health services where their employer permits businesses to be conducted. And before it said where the employer regularly conducts business and services. So it does allow a little leeway for, if they're doing, and I think the reason, if I remember the discussion well, is because social workers sometimes do more commonly do site visits, going to a home. Now, I know that it still leaves a little bit of a gray area, but I think when we say that the supervisor provides services to clients at the same site, are they working out of the same company or general vicinity? Is the supervisor available and also practicing there? So that if there's a problem that they can step in, and do they have experience seeing clients? Because we want in the private practice or the professional corporation setting, I think we want the supervisor not to just be, because there's not necessarily as much oversight in those settings, but we want the supervisor to be more of a hands-on worker rather than just somebody who's sitting and supervising a bunch of people who are in training.
Yeah.
Do you agree, Christina?
No, I agree. And I'm thinking about, the example that Ben, you used, about like the home visits and stuff. And so, I'm trying to think that, that is really about like the kind of like the mode of intervention, where you want to, implement those, therapeutic intervention. And so my understanding about location really is about, the offices, where really, that's, you have to have like some sort of home, for your business, right? And so, you can do a lot of outreach, you can do a lot of, going to the hospital, and yet it's really about, where is the home base, of your business, located. So in that sense, it's kind of like, up to discussion, but at the same time, I feel like that, it's also not really that contradictory, to what we propose.
I don't know that it's causing a problem.
Right. Yeah. No, thanks for bringing it up. I mean, that's a good point to clarify.
Right.
Yeah. So does it make sense?
That makes sense to me, yeah.
Cool. So hi, Jennifer.
So thank you. I think this has been a really, informed, discussion. I'm obviously learning everything. So thank you for your patience with my comments today. And we agreed that, there should be some more research and feedback before making any additional changes to the exempt and non-exempt sites. Because we had some questions about some school services, crisis hotlines, and those types of entities. And so we do appreciate your thoughtfulness before making any additional changes. Thank you.
Thank you very much. It's nice to hear the support from the stakeholders. Any other comments? Okay. Oh, Dr. Supiro.
This is a really valuable conversation, so again, thank you. Maybe a conceptual way to approach it is to characterize it in terms of a sustained, informed presence in the characterization of the therapeutic work. And that sets a standard that has some flexibility, but defines the accountability that the supervisor has to maintain in a sustained and informed way. So the presence doesn't have to be physical, but it has to be aligned with the characterization of the clinical work.
Very good. Thank you. So any other public comments? Good. So no change.
No change, then we'll
That's what
run
I'm
the bill as
hearing,
approved.
right?
Yeah.
And so in that sense, we don't need a vote because then we're not
We're
not
not doing anything. We're just, the approved language stands. yeah.
Yes,
Yeah,
yes.
so not going to the board, no, just, we had the discussion, we're in agreement.
We're in agreement. So now, technical question though. Now, this is the PNA, so we recommend that no change, but does the board has to recommend no change?
No.
Okay.
I don't think that
So
usually,
we're representing
yeah,
the board now.
right.
Good,
They
good,
kicked
good.
it back. I mean, I can see where we would provide an update that we looked at it in at that time.
Yeah, I think the update would be good. I'd never want to do
Okay.
something behind the board's,
Okay,
board's back. I think the update would be good. Yeah.
okay,
Okay.
okay.
Perfect. Thank you. All right. So then it comes to our third discussion, and that's about the custody of client records due to licensee's death or incapacitation. And it's Roseanne again.
Yes, so we discussed this at our October Policy and Advocacy Committee meeting, and we decided that we wanted to gather a little bit more information to continue the discussion. The item for discussion is what should happen to client records if a therapist dies or become incapacitated. So when we discussed this in October, the committee wanted to get a little bit more information about informed consent and possible coverage of the topic in the ethical guidelines. So we did a little bit more research about informed consent and the ethical guidelines to report back for that. So in terms of informed consent, the board's licensing laws don't specifically require what would be characterized as a single informed consent document. There's no requirement for a comprehensive document that says it needs to have X, Y, and Z, and you need to provide that to your clients at the beginning of therapy. There's nothing like that. There are some specific pieces of information that are required to be disclosed to the client. That includes the fee to be charged for services. There's a requirement about that. There's a requirement that the client must be informed about telehealth if that's going to be used, and they have to consent to it, and that has to be documented. There's a requirement that unlicensed associates and trainees need to inform that their client that they're unlicensed and under supervision. And then there's the new requirement starting in July that the client must be provided about a notice about where to be filed as a complaint. But these requirements aren't really, that's not in a specific informed consent form. Some states do have specific laws about informed consent, comprehensive informed consent, and they seem to specify certain things but not others in them. So for example, Texas, which I've included the law in attachment A, requires a signed informed consent. It has to cover things like fees, limits on confidentiality, counseling purposes and goals, and the plan for custody of clients' records in the event of the licensee's death or incapacitation. The state of Colorado was another one that a stakeholder brought up at the last meeting that asked us to look at. Colorado does require what it calls a mandatory disclosure of information to clients, and it includes various things, an explanation of the regulation of mental health professionals, degrees, the person's degrees or certifications, contact information for the regulating board, but it doesn't require any disclosure information about custody of records or what to do in the event of the practitioner's death. So it kind of leaves that out. So it seems like what I got from that is like it's hard to cover everything if we were to do such a list. Some things might get left out and others might be included. So and CAMP actually published a really great article that I found several years back, and they'd updated it, I believe, in 2017, and I included that in attachment C because it was just a really informative piece about informed consent and the different requirements. I also looked at the relevant professional associations and whether they touch on this in their codes of ethics, because that was raised as a question as well. And so most of them do. The ones that I found, the National Association of Social Workers Code of Ethics has something about that in there, that therapists should take reasonable precautions to protect for that situation or account for that situation. CAMP has something in their code of ethics that's suggesting a professional will or providing information in the case of emergency. American Counseling Association also requires counselors to take reasonable precautions to account for their possible closure of practice or their death or incapacitation. American Psychological Association has a mention in there as well. And then I also noticed in just doing some research and some stakeholders, thank you, Jan Lee, provided some information to me via articles, that a lot of professional associations from time to time will publish articles about what to do in these situations. I included an example from NASW, also had found an example from the APA. So there is information out there about what to do. And then as we discussed last time, there's some examples of what other states do. There's a wide variety of things. Some of them are very specific and possibly onerous. Florida requires the executor of the estate to take out ads in the newspaper for a certain number of weeks, and it's really detailed about what's required. Oregon, they requires somebody to file a name and keep current a custodian of records with their board. And then the state of Washington just says that they need to make provisions for the transferring of records in case something, unexpected were to happen. And they don't go into a lot of detail. They just say it needs to be done. So there's various examples out there. And so I think that provides us a little bit more information and a little bit of a clearer picture about options. It seems like the professional associations cover it pretty well. And it seems like our informed consent, we require some things, but we don't really have that specific requirement. So we can just kind of have a discussion about what the committee might want to do about that.
Thank you, Roseanne. This is really cool because I think this is a follow-up discussion from the last PNA meeting, and now we have more information in hand. So I'm actually really impressed that the professional organizations code of ethics already cover, this part of it. And so, so it's a legitimate concern, and I think it's a very important practice, for the therapists, to really inform the clients how they handle their records. So when when they're incapacitated or upon death. So I think this is important. My suggestion is that it's important to have language, in our law, to really give the direction, for the therapist, what to do. And yet, I don't think that we need to go into details and say that, you need to do whatever newspaper and the ways of, how you handle, the records. And so, I would love to, see, the language like the Texas, but at the same time also add the how they handle, the records should be consistent with HIPAA, with the confidentiality. So I think that's, always, the discussion is like, who really owns the record? But at the same time, if we, because nowadays it's not just about, the paper records anymore. You talk about the electronic records. So who really, how do you handle this? And how do you actually, transfer those records or have the clients have access to those records, but based on the confidentiality? But so my thinking is that if we make it, set the direction and yet, leave the room, for the practitioner to decide what they want to do, I think that would probably create a little bit more flexibility, but at least clear, to the public that this is what we want to do. So, Betty?
So I certainly appreciate the time that you spent, Roseanne, looking into this. I have the same exact concerns that I had when we discussed this the first time, which is the only point of interface in which we could actually take action would be if they failed to put it in the initial agreement. Because beyond that, we don't have an enforcement capability. And my concern, while it's absolutely valid, I mean, I checked with our LEP population, their code of ethics includes it. I believe we just heard all the other professional associations already include it in their code of ethics. My concern is, do we want to start teasing out and pulling out all of these things that are absolutely recommended practice, ethical practice, but where does it, this is a slippery slope. I mean, so now we're going to add this to one more thing that people have to sign off on their, before you see a client, you need to. And we've already put where you file your complaints. We've already got, I mean, we keep adding things. I could just see that, yes, this is a valid point, but at what point do we say, everything in the code of ethics is a valid point, and we can't import every practice's code of ethics into that informed consent. And that would be the only place that we could actually identify noncompliance. So that's my two cents.
And I would say that Betty makes a really good point about incorporating the code of ethics into our statutes and regulations, and it would be onerous. And the Federation of Regulatory Boards and Dale Atkinson, who is counsel to ASWB, recently addressed that issue with some very good, I would have to pull the paper back up, but some really good, valid reasons why you do not want to incorporate the code of ethics into your statutes and regulations. It's really more of the companion to practice.
I guess that, my thought is to, I see your point. I totally see your point. At the same time, there's also some very legitimate issue. For example, when you have a therapist who see, child custody, cases, and those records are supposed to be, are necessary to be subpoenaed, then how do you manage those things? Because when you don't have a plan, then, that it creates more trouble. It's going to harm, possibly, the consumer or create obstacles. So I think it is a slippery slope. I totally agree. But so that's why my thought is like, how can we maybe put the sentence, put the direction in, but not confining. But, we can certainly continue to discuss more. Because I think there's a reason why this has been brought up, due to probably, as the baby boomer, getting older and, or, anybody can have misfortune.
Right,
So,
right.
yeah. So, but I
Yeah.
I hear that. I understand.
Yeah, I think, where I see this more often than not is in relationship to individuals submitting their clinical hours. That's where I see the problem more so than any other time, because they forgot to get the supervisor to sign off on the statements or the verification of their hours, and now what do you do? That's
But
where
see-
the death
Right.
incapacitated a supervisor. So
So, so if those, I'm thinking that, that would be a little snippet for us to see the magnitude of the issue. Because, supposedly, those supervisor, they have to have, either they have to be in practice, or they have been in practice, because that's one of the requirements. And so in that sense, if they're currently in practice, along with providing supervision with the interns, then it means that, if they cannot get the person to sign the, sign the supervisory form, then, then it means that, all those currents, client that they're seeing, all the records that supposedly not even past 7 years, because that's another law, right? If, the client terminate or, you need to keep it for 7 years. So I'm looking at that 2 out of 5, years of the direct practice, and then, you have to keep it out of 7 years. So that's create a little loophole, that we don't know what to do. So there's no clear direction. Steve?
I think where I see it mostly is I always get the question, what do? We get the call from the friend of the therapist who passed away. They don't know what to do with the records. I'm kind of in agreement with Betty. I don't like to put language in there just to say, hey, you might want to look to do this. I think it serves better public communication. Hey, read your code of ethics, maybe even publishing code of ethics on our, getting it out there so they have a direction on what to do, because like you said, we don't have any enforcement actions with that. That really has to go with, you're going to look at HIPAA laws and a whole bunch of other laws that it's not in our purview. And maybe we bring that to light for them to look at that and say, here's what you're responsible for, not necessarily in our statutes and regulations, but for record keeping, here's what you need to look at, and then go from there. Because just adding additional language, I think it's, beneficial. I don't know. That's my opinion.
Thanks. And Betty Steppin and Betty.
I think, I guess what I'm hearing is like it's two different issues. We are the custodian of license and standards and statutes, but we're not the custodian of the patient's records. And so I agree with Betty that if we were to step down this slope, and I think it's a steep slope, we would then be entertaining the custodian of records. And I think our business, at least as I understand it, is the custodian of standards and quality and consumers, making sure they're safe, not the custodian of their records. And although I agree that that's an issue, because if I were seeing a therapist and they were to accidentally pass away, no, I mean like in an accident or something like that.
Most people don't do it on purpose.
I think that a lot of customers would say, well, then that's all well and good, but where are my records? And that, well, you're going to maybe you have to sue the entity. I don't know, to get a hold of your records. But I think that the fallout from that could be lawsuits. It could be all kinds of stuff. And I'm not sure this board wants to get in. So if this happens, then this is the statute. And if that happens, then it's this. And then if that happens, you know what I mean? It just starts compounding itself. So unless I misunderstand our charge, I think I fall back on we're the custodians of making sure that the public is safe, not the custodian of their medical records. That would be up to the client themselves. I think needs to be when they're seeing a therapist, that's a conversation you have. So if something were to happen, where do I come to get my stuff? Because I know that, who cares about what my therapy sessions look like? But there are people out there who are high profile people that a lot of people would love to get a hold of those things. So I think that's a bigger and grander conversation for a different board, perhaps, or a bunch of lawyers that would sit and think about all the different things that we would have to put into place to make sure that those were secure. So that's just I'm just seeing that there's a definite difference between our charge and a different charge. Pardon?
Yeah.
Well, then there's, right, but HIPAA doesn't have any language either on how to get your records.
So I wonder, I have a question. So what is the practice of the other boards in California? Because I can tell you, I experienced one time, not myself, but, we have a psychiatrist, up in my area, that he just disappeared. I'm serious. He had an office one time, and then next week he disappeared. And then the clients started to ask, where is my medical record? Because we're talking about mental health clients, the psychiatrists, they need their records to continue it's a real story. It's not a story, it's a real fact. So I think, I know that it's very, very difficult, when we talk about the, ethical practice versus the lawful practice. But at the same time, it does happen, and actually, eventually, I think they tracked out that psychiatrist actually moved out of California. But at the same time, no records left. So yes.
I'm just thinking down the road, look, if we go this route, we mandate it or make it required, how do I enforce it?
You can't enforce with a deceased person, right?
Exactly.
Yeah.
Exactly. So I have no mechanism.
Right.
So that's where I think it's, the code of that ethics is
It's the way to
is
go.
more effective than what I can do.
And Steve?
Just really quick too, and so it's, I don't think, like we said, it doesn't really fall within our enforcement realm, but it does in the public protection realm. So how we do that though is we could actually, if in the future, educate people about what they can do to protect their records, what they need to, what conversations they need to have with their, and do that and put it on the actual consumer to almost in a way police or, understand how important those records are. And then maybe that will bring to light for some therapists who may not be keeping excellent records or don't have a plan to actually think about having a plan. Even educating them what could happen, because I'm sure people are getting sued over this, therapists, I'm sure, over not having the records and such. So
Right. I think, do you want to say some more?
Well, one more,
Yeah.
one more thing before we go to our public. In keeping with what we've all said, certainly, I don't know whether we could serve as as a forum to encourage, advise our license holders to actually refer, that this is an issue that has come to the board, that we've heard it as a concern. Just remember in your practice, as you set up your practice, as you implement your practice, that you refer to your professional association's code of ethics and take this into consideration.
And maybe it's best practices, maybe it can be included in a newsletter article, maybe the associations could do a little snippet also as a reminder, have this plan in place. I know.
And even the educational entities. I mean, even the institutions. I mean, so I'm 100%. It's not directly our job, but we can certainly serve as an advocate or as a voice to say this is important to consider, and then goes back to
The organizations, yeah. Yeah, the stakeholders, yep. Okay. Kenneth?
Yes, Kenneth Edwards, CalPIC. I echo all of the comments. I mean, I would love to be the person who assigns you the work and takes it away, but I'm sure that you all do not want any more work in having to enforce this type of a thing with a dead person, which you may not get anywhere with that. And the other piece here, I think that just by having the conversation itself throws it back in our court, so that we know that it's an issue. We know to talk to members about it. We know to find articles and distribute. What the board might be able to do is, and what the BBS does, is just put an article out on it that we would pay attention to and then pass it on to people. I remember early training as a therapist. You learn these things in graduate school. You learn records, you learn ethics, you learn to pay attention to the code. So I think that's enough.
Thank you, Kenneth. And Jennifer?
I have notes, official notes from my Smart Association people. So this has been a great discussion. We have done articles, as you noted before, in the past. It is, part of our code of ethics. But we agree that it's a real issue, and I know that we'll continue to educate our members on this, and update articles is necessary, because it is critical, for consumer privacy, when something unfortunate happens to their therapist. And so, again, this has been a great conversation. We do agree that it would be very difficult for the board to be able to enforce, given some unfortunate circumstances, but it's a very thoughtful conversation. We appreciate that. Thank you.
Hi, Ben.
Hi, Ben Caldwell. What Jennifer said. It's been a good, useful discussion. I really appreciate that this is you're making a distinction that's an appropriate one between what is really an enforcement issue, which this is probably not, versus what is an issue of public protection, which in some ways this is.
Yes.
And so when you encounter an issue like that, there's you have limited mechanisms at your disposal for how you want to address it. If there is appetite among the board to take on this in some kind of a substantive way, and there may or may not be. Just speaking as a clinician, I've had colleagues who passed away unexpectedly. I've been aware of situations where somebody had an electronic medical record that no one else could access because that clinician hadn't taken the steps necessary to do a professional will, to create the kind of legal authority that would be necessary. And it creates all kinds of problems for colleagues and family as well as for the public. If there is appetite to pursue this, which there may or may not be, and it's understandable either way, Roseanne, the Oregon approach that you found, where the board simply gathers information from licensees about who they have designated, another license holder that would be a point of contact for the public. And you'd need to put all kinds of caveats and sort of disavowals on it too. Like you don't want to become a custodian of records. Deborah, you're spot on about that. But I wonder about the possibility of just making that additional information that a licensee provides that is publicly accessible for a sort of secondary custodian of records for those clients who maybe were seeing somebody in private practice. Obviously, it wouldn't apply if somebody was, employed by a corporation where the corporation owns the records, et cetera. But that would seem to be a nice way of balancing public protection while also not becoming a custodian of records and not worrying so much about the enforcement side of it. Thank you.
Thank you very much, Ben. And Jan Lee, good morning.
Jan Lee Wong, NASW. I have a big problem with Ben's suggestion. The first thing is, Ben already mentioned it, what kind of workload are we talking about? How many licensees do you have?
120,000.
And how do you keep track of all these designated, whatever you want to call them? Secondly, I'm not an attorney. There are several in the room, or at least one. And when a licensee says this person is responsible for my records if I pass away, and that person agrees, is there some sort of liability that attaches? In other words, somebody might say, okay, I got the records from the designee and they don't look right. Something's missing, Exactly. So is it fair to, put this on the person who, out of their good heart, generosity, to say, oh, okay, I'll be your backup, and then attach this potential liability to them? Then the other thing is, really, what are the records for if somebody passes away? So I've heard many times over the years, most professionals feel that if a client wants to see their records, they would like to go over the records with them. They don't just hand them over and say, read them and figure it out yourself. They say, this is something we did together. And we went through the whole idea of therapy together. We went through the whole idea of gaining insight, thinking about how your behavior does this or how your behavior results in that. And it's better to really go through it together than just simply to hand off written records to somebody. And then the same thing applies to the executor of the estate. If you are starting to say you shall do this and you must do this and you must keep the records for this many years and you must hand them over, you're really getting into what probably there's a whole huge section of law books on estate law. And do you really want to go down and start making estate law? So I like the original idea, which is this is pretty well handled in the codes of ethics. We do a good job in trying to educate everybody to handle this in the code of ethics and kind of, let them figure out what course of action to take with their clients rather than have this one-size-fits-all and this, pardon the expression, dictate from the state as to what you have to do. Thank you.
Very good. Any other public comments? Okay. All right. So it looks like, the general consensus that, the code of ethics, right now is sufficient, to provide guidance for the licensees, to, or the registrants or the trainees, how you handle the records. So, Roseanne, so in that sense, so you think that discussion is sufficient to, address, the concerns that brought, to the staff?
Yeah, I think that we've had the discussion. We've kind of made it we've made a general awareness of the issue and had a discussion and provided some different aspects of where it's addressed. And I think that it's been a good discussion, and I think it's okay to close it.
Yeah, definitely. So, I think that it really is about, how do you, and I kind of agree with Ben, it's not just about the enforcement, but about the public protection. And also, I think we have a job to educate, the public. How do you actually, set, what is the quality of the mental health services? And I think that education piece is really, really important. So whether it's set in, regulations, I don't know. But I think it's also important that, maybe the board, can use that education route, to really talk about that also.
I agree. I think a letter in our newsletter for the
Yeah.
practitioners, and I think, now that we're almost full staff, we can actually gear up and start doing some consumer informational brochures.
Yeah.
And I think that's just goes a long way.
It's definitely a preventative, measure, and I would never want to see the same thing happen, like the psychiatrist I talked about, to happen to any of, our licensees, because the ramification is huge. And yes, we cannot enforce it, but I think we're doing a very big disservice if we cannot protect the public, for them to know their rights and for them to know, how their, privilege has been protected and being handled. So, all right, so I think we don't take any action, so no votes is required. Okay, so we can safely move on to now our next item, which is the report for the board rulemaking proposals, and that's Christy. Oh, wait.
The
Okay, I see.
legislative.
Did I miss something?
We skipped the legislative update.
Oh, that's right. I flipped the tab a little too fast.
It's okay.
It's Roseanne, legislative update.
So this will be quick. So the board is pursuing 3 legislative proposals this year. The first one will be a bill to define practice setting definitions. We're working on getting an author and getting all that set up, so we should see that introduced sometime next week, hopefully. The second bill that we're pursuing is a fee increase proposal, as we spoke about at our November meeting. So we're working on that, and that should be introducing in the next few weeks as well. And then finally, we have our omnibus proposal. That's a kind of a collection of more non-substantive or general items, including the one item we talked about today about the language for AB 630, the amendment there. That's either going to go in an omnibus bill or it possibly the board is up for sunset this year, so there will be a sunset bill. And so there's been some discussion with the B&P committee that if it's non-substantive enough, they might just put it in there. So it'll either, some of those items that are a little bit more technical will either show up in the omnibus bill proposal or the board's sunset bill.
So just to clarify, so what we talked about, the number one, thing about the file the complaint, and the language is already in that omnibus bill.
The omnibus bill is not introduced yet, and we had not submitted that particular piece to the Business and Professions Committee because we did not have board approval yet. So now, once we get board approval in March, if we do, we'll be submitting that separately to include either in the omnibus bill or the sunset bill.
Thank you very much. Okay, any question, discussion? Okay, then we can move forward to the real Christy portion of it, the rulemaking proposal.
Yes.
Update.
Thank you. So the first one on our list are the AB 2138 regulations. They are in the DCA final review process. Do you want to say anything about those?
So on that particular, it is in the final review. We have received some notification that there may be some suggested language changes to what the board looked at. We're not sure. It appears they're not going to be very substantive, but we'll see. But I wanted to definitely alert the board that we may be bringing language back at the March meeting to discuss.
So in that sense, though, do we restart the process again, or is it just,
Yeah, not restart, but we'd have to go out. If it's substantive, we would have to go back out for a 15-day notice. Correct?
that we start from square one?
No.
Okay.
I mean, we're in the last leg of it, but, I mean, there's been a couple of, because it's so, all 40 boards and bureaus are doing this language, and the DCA Legal is working with the Office of Administrative Law to, sort of pave the way, and we're to make sure that it's consistent across the board. So that's sort of the deal. Roseanne, you want to add to that?
I will add that we are in good shape. We're us and Vet Med Board are sort of the two. We're sort of neck and neck to be the first ones out of the gate. So we're doing well. We're doing well in terms of it. But part of being at the front and being the first one is everybody's still trying to figure out the process. So we kind of get that. It's good that we're first and on the ball, but we kind of get the little bumps in the road that haven't been smoothed out yet for us by being one of the first ones.
Think of Breeze implementation, first phase versus the second phase. Lessons learned. So we don't see anything as it being totally insurmountable, but I just wanted to give you that stuff just sort of popped up recently, so I thought it was important to share.
Yeah, absolutely. Thank you.
Sure. And so another package is has to do with enforcement process. This would update the board's disciplinary guidelines and uniform standards booklet, but this is going to need to wait until the passage of the AB 2138 regulations because it's related. The package on exam rescoring, application abandonment, and the APCC subsequent registration fee has been submitted to OIL for final approval, so we're expecting that in the next couple of weeks, and then those will become final. It's a quarterly approval, so it would be an April 1st effective date. These are really minor, so there won't be any dramatic effect at all, but those are coming up. And our supervision regs, they were just noticed today to the public, so we have our public hearing date on March 23rd. So that's, we'll be interested to see what comes of that. I would anticipate that we'll get some public comments because there's some pretty, fairly major changes, but we shall see. And then there were a couple of other reg proposals approved by the board in November. So the continuing education regulations, I'm working on preparing that for the initial review process. I'm getting fairly close. I had a lot of forms to work on, so we switched over to regs now. So getting fairly close for that one. The other one were some technical changes, and so that one won't be as difficult to prepare. But that's not as high of a priority, but that will come next. So,
Thank you so much, Christy.
thank you.
A lot of paperwork, huh?
Yes.
Awesome, thank you. So the next agenda item is public comments for items not on the agenda. Any public comments? Okay. And then we're going to move forward to suggestions for future agenda items.
I think at the last meeting, I raised the matter of some type of law and ethics testing for graduate students. They're in field placements, they're providing services to clients. Might there not be some type of instrument that kind of formalizes the expectation and at the same time, I think provides a vision for graduate students who are moving towards licensing of what the license examination is going to involve? and give them the opportunity to experience some of those questions and maybe provide the opportunity to see how those questions and the actual law and ethics guidelines in the NASW Code of Ethics, but also California Business and Professions Code are tailored to their specific internship settings. And working with the universities, we could figure, and I've raised this with the California Association of Deans and Directors, to see how collaboratively we might be able to work with the board and come up with a progression of not only demonstrating knowledge of core, but the ability to be able to think in the moment to apply the application of those standards to specific practice moments. So just something perhaps in the future.
So I would like some clarification about what that vision looks like. If it all happened in your, we said, yes, we did what you're asking. What does that look like?
You know, it might be interesting to come up with maybe a modified law and ethics exam, 25 questions, key things about reporting, protection, confidentiality. You know, I've reviewed that wonderful new test instrument knowledge that you have in terms of the different knowledge and skill areas, and really acculturating the students to, at the beginning of their graduate education, this is the standard of practice. And maybe just questions from those key areas, a couple of key questions that demonstrates the seriousness of bringing that material into their actual practice. So I don't know that it necessarily would have a binding effect in terms of their, you know, progressing in their master's education. But I think it really gives the teaching folks an opportunity to be on the same page as the board. I mean, I don't see many of my colleagues here. And I think it just provides an opportunity to update legislation and begin these conversations with students. And in terms of consumer protection, I mean, as you all know, in their internships, they're providing really major services to consumers.
And so in developing that instrument, is it the vision to administer that exam while they're in school?
I would think in the first year.
Okay,
while
when they
they're at
first start grad
school.
program. Okay.
Yeah, because I know what we do at State is we go, and Jan Lee and one of your colleagues, Christina, have been involved in this, is to give the students in almost an abstract way a sense of the code of ethics, and okay, now you're getting yourself into this. But something perhaps at the middle of that first semester where they have to really answer those questions and demonstrate not only awareness, but their readiness to apply those standards to practice.
Okay.
So instead of the full exam, but what I'm really proposing is just a beginning conversation to brainstorm and see how we might collaborate in bringing something like this forward. Thank you.
Thank you very much. Any other public comments? Oh, no, suggestion for future agenda items? Okay. All right. Very good. So I think this is coming to our all favorite agenda item, which is adjournment. So our time now is 11:53, and thank you very much for such a productive discussion. Thank you.